talk about, I had two handouts, I hope you got both of them. This is one, and then another one says involuntary commitment. And I'm not a very good Xeroxer, they're stapled in really unusual places. I'm sorry about that. I tried. Okay, here's some more out there. So for tonight, I'd like to talk about a couple of things. First, when does the state's attorney's office come into play? When does the court system get involved in a person with mental illness? Second, how does the court system get involved with a person with mental illness? Third, what can you realistically expect from this whole process? And then I want to talk about a new law that came down, I think, July 2010, which concerns orders for outpatient admission, which seems like a little contradictory. How can you be admitted for outpatient? Then, if we have time, I want to talk just a little bit about involuntary treatment. And then, lastly, a few alternatives to the court system and additional tools so you can help for yourself. So first of all, when does the court system get involved with someone with mental illness? And why is the state's attorney up here talking about mental illness? Is mental illness a crime? Of course not. It's not a crime. But our legislature has recognized that there are certain situations when the law is going to step in and intervene. And those are basically emergency situations. Sometimes families wish the law would intervene in a little bit less of an emergency. But because of our 14th Amendment liberty interest and our free speech interest, it's very difficult to restrict someone's freedom. So our legislator has decided that in certain situations, the court system can get involved. And those are, I will continually talk about these three. When someone is a threat to themselves or someone else, when someone is unable to take care of their basic physical needs, and then a new prong is when someone is non-compliant with their medications, but they have a history of non-compliance that indicates their non-compliance leads them to deteriorate so much that they're unable to take care of themselves, or they're a threat to themselves or someone else. So that's a wonderful new law. You don't have to wait until you actually deteriorate to those levels. So how does the court system get involved? The court system gets involved if anyone over 18 files a petition for involuntary treatment or involuntary commitment. A petition is a legal document. A petition is a document that basically asks the judge to do something. So if you sign the petition, you're the petitioner. In the petition, you name the patient who must respond to the allegations you're making. You're making allegations that this person has mental illness and needs help. So the person who must respond is the respondent. So we can have petitions for involuntary commitment and petitions for involuntary treatment. Before we go any further, a problem that a lot of people have that we talk to in our office is, how do we get the patient to the hospital? It's a really big deal. We don't know how to get them there. So if you turn to the first page, there's several ways you can get a patient to the hospital. First is voluntarily. Easy. Get in a car, we're going to take a ride, go to the emergency room, or go to the mental health center. We often hear the families say, come on, get in the car, we're going out to dinner, and they end up in the emergency room. So, whether it's voluntary or not, I'm not going to comment. A second way to get there is a certification by your own doctor. Psychiatrists should know that there is a form called a certificate that can be filled out when the psychiatrist believes that someone has mental illness, is currently symptomatic, and is threatening themselves, is unable to take care of their basic physical needs, and has a severe, has a non-compliant medication and is expected to severely deteriorate. If a doctor feels this way about a patient, a doctor can fill out the form, the certificate, and also a petition, or just the certificate. If the certificate is filled out, and even a family member can fill out the petition correctly, then, as you can see from the law here, in counties over 3 $3 million, you can take these to your local police, and they should be able to transport your loved one to the mental health facility. So this is a situation where the patient does not want to go, which is most situations that we see. I can tell you that we don't see this too often. And it's not in Cook County, which probably, as Vanessa said, maybe we do more mental health than other counties. So this is very rare, a very rare approach. The third way to get there is by the police, which is probably the most direct. If you really have an emergency on your hand, whether it be in your home or on the streets, quite often the police will respond. The mental health code empowers the police to detain someone who is a threat to themselves or someone else if they suspect, based on the behavior, that they're suffering from mental illness. This law allows the police to take the patient directly to the mental health facility. A fourth way to get a patient to the hospital is to come to our office at 69 West Washington. There are attorneys who are there daily. There are no appointments taken, and we need someone with first-hand information to come and tell us what their loved one is doing that has shown that they're an immediate threat of danger to themselves or someone else. We don't really get a lot of unable situations here unless you're unable to the point of being in immediate danger of harm. What we do is we'll interview the patient, we'll interview the family member. If we feel like there's an emergency, this is an emergency situation, then we will prepare the paperwork. We will walk the family member over to the Daly Center after notifying a judge, and we'll have a small hearing, and the judge will listen to the evidence. And if the judge thinks, yes, this is truly an emergency, I'm going to order the police in their area to pick up their loved one against their will, bring them to a mental health facility against their will, and examine them against their will. As you can see, it's a huge deprivation of liberty to have all these things happen, and that's why we need an emergency situation. And a last way that I sometimes tell some people who come to their office is, I think it's often a good idea to obtain an attorney, not because I am an attorney, but because having someone with mental illness is consuming in your life. You have so much going on, there's so much strife, and if you have already obtained an attorney to initiate guardianship proceedings, you have an attorney to hold your hand, guide you through the process, and also, one step to the hospital in many cases is not the end of the story. It's just a Band-Aid on the problem. So if you do hire an attorney, you will have constant, you have somebody, your go-to person, and what do I do next? This happened. But I do have to caution you to make sure you find an attorney who's experienced in mental health, because there are not a lot of attorneys who are very experienced in mental health and could give you an answer right off the bat on what to do next. And also, we'll have to ask Joe Monahan about this, but I think in some cases the fees may be reimbursed by the guardianship estates if you hire an attorney. But you're assuming, first of all, that there's money in that guardianship estate. So, whether the alleged disabled has any money or not is a whole other question. Some obstacles to getting the patient to the hospital is the confidentiality. Oftentimes, maybe Dr. Goldman can comment on this, we don't find Northwestern to, we don't have a problem in our office with Northwestern to disclose records. They're always very forthcoming, and that's because the mental health law provides an exception to the confidentiality rule, the privacy rule between patient and doctor. If the information is necessary to initiate or follow through on a mental health hearing, the information can be disclosed. A second obstacle to getting the patient to the hospital is the fact that there has to be an emergency. I'm sure many of you, if you have mental illness in your family, feel like, why do I have to wait till it's an emergency? I want this taken care of now. I want this person to get help right now. But unfortunately, you have to wait until the person is a threat to themselves or someone else. The person is unable to take care of their basic physical needs to the extent they're harming themselves, or we have a severely non-compliant person with a history of threatening or not being able to take care of themselves.